Welcome back. Now, so far we've talked about contracting systems, and we explained that contracting systems must do several things. Contracting systems must provide the elements necessary for a valid contract. They must guide the performance of the contract. They must tell us when the parties have performed. And finally, contracting systems must provide for remedies in the event of a breach of a contract. So in this lecture, we take up the second phase in terms of looking at what is performance. Now, breach, don't be concerned about that. Breach simply means, in a legal sense, a failure to perform. A failure to perform. So it's the opposite of performance. Now, we know that every party to a contract undertakes certain obligations. That's what a contract is. It's an exchange of rights and obligations. Now, in a sales contract with a buyer and seller, each party has obligations. The primary responsibility of the seller is to deliver conforming goods in the manner specified within the contract. And the primary responsibility of the buyer is to take delivery of those goods and pay the price. So these are the expectations that the parties had, going back to our first lecture on expectations. The primary responsibility of each party is already decided in every contract. The seller is to deliver conforming goods. The buyer is to take delivery of the goods and pay for the goods. If a party fails to perform, the non-breaching party, the party that has not breached, can seek a remedy. And that remedy can come either from a court or from an arbitration panel. Nevertheless, the law gives to the party that has not breached a remedy, because that's the other thing that a contracting system does, is to provide remedies. So in the second half of this lecture, we'll be talking about the remedies that the buyer would have and the various remedies that the seller would have. Now, before we go on, I just want to make a brief point. The reason we call it the non-breaching party instead of, the innocent party, is that you need to get away from thinking about breaching and non-breaching in terms of morality. It's not the guilty party and the innocent party. It's the party who breached and the non-breaching party. The CISG will refer to the non-breaching party as the aggrieved party. Now, the remedy in a contract situation, in any contract situation for the sale of goods, is essentially meant to put the non-breaching party in the same position it would have been in had the contract been performed. So as we go deeper into this section of the course, and eventually we're going to talk about how you calculate damages. Damages are a form of remedy. What you should keep in mind is that what amount will it take that will put the non-breaching party in the same position it would have been in had the breach never occurred, had the parties fully performed. In a contract situation, damages are meant to put the parties in the position they would have been in had the contract been performed. In tort law, negligence and such, the remedy is meant to put the parties back in the position they would have been in before the tort ever occurred. So keep that in the back of your mind. So in this lecture, we're going to study how buyers and sellers perform contracts, and then we're going to discuss the remedies that are available in the event a party fails to perform. So we'll start with performance of the contract. And we said that each party to a contract has certain responsibilities. The responsibilities of the seller is to deliver conforming goods. To deliver conforming goods. The buyer must pay the purchase price. The buyer has to pay the purchase price. These are the two expectations that each side will have at the onset of any contractual relationship based on the sale of goods. The seller's going to deliver the goods. The goods are going to conform to that which was anticipated in the contract. And then the buyer will pay for the goods. Now, when we talk about performance, Performance issues traditionally boil down to these three elements then. First of all, delivery. Was delivery made or not? How was delivery to be made, and how did it actually occur? The second element is conformity. Did the goods conform to that which was set out in the contract? And finally, payment. Did the party required to pay for the goods? Did the buyer pay for the goods? So when we look at those expectations and those obligations, essentially, when it comes to performance, we're going to look at these three elements: delivery, conformity, and payment. And so we'll take up each of those in more detail.